sound there? Good sound?
Yes, sir.
Okay, are we ready? Good afternoon. Yesterday, residents of our capital city, central Indiana, our entire state, and many points across this nation stood witness to a miscarriage of justice imposed by Judge Mark Stoner of the Marion County Court System. Many of the first reports suggested that Judge Stoner had sentenced the defendant to 40 years for the killing of Officer Breann Leath. This is not correct. Our plan today is to break down what actually happened so that the community we serve, and just as importantly, police officers who are risking their lives daily, they can fully understand what transpired. First, our heart remained broken for the Leath family, including her young son, her parents, sisters, biological family, and her extended family in blue. We also remain firmly focused on the defendant's girlfriend, who was also a victim of criminal confinement and attempted murder. We also must collectively not lose sight of the additional officers who were fired upon, and by the grace of God, were not struck in this violent series of encounters. The city of Indianapolis remains scarred by the tragic death of Officer Breann Leath that was made on our behalf and not her own. However, she was willing to lay down her life in selfless sacrifice, and that will never be forgotten, regardless of the subsequent sentencing. First, we fully support the argument of the deputy prosecutor in seeking the maximum sentencing for all 6 counts that the defendant was convicted upon. As such, the maximum sentence allowed under law was 63 years. That means if the defendant received all available good time credit, he still would have served 47.25 years in prison. Instead, the judge chose to deny the state's argument and instead sentenced the defendant to time served for the killing of Officer Leath. This time served equates to the approximate 4 years that the defendant has been in custody while awaiting trial and credit for good time behavior. This amounts to as little as 5 years for killing Officer Leath. Troubling as well is that the judge sentenced the defendant to 40 years for the attempted murder of his girlfriend, who he shot in the back as she was fleeing from the defendant after she was escaped from his criminal confinement, after he wrestled her and took her cell phone from her that she was using to get help. And worse yet, Judge Stoner made a decision to then suspend 15 years of this sentence, reducing it to 25 years executed, which now means that the defendant can be back on the streets, your neighborhoods, in 18 to 19 years. So let us be clear. The facts showed that the female victim called 911 to get help. The defendant had stripped her of her phone, talked with the 911 call taker, and knew the offer to send help to the apartment. Police officers were immediately dispatched to the location, and upon knocking on the door, the defendant had then wrestled a gun from the female that she had retrieved to protect herself from him, and the defendant fired 8 gunshots from his gun through the wall, striking Officer Leath 2 times in the head and narrowly missing several other officers who had also responded to the initial call. But it does not stop there. We also know that the female then escaped from the defendant's confinement and attempted to flee the apartment building to seek help. The defendant then exited the apartment, stood over a dead uniformed officer, and shot the fleeing female twice in the back as she fled for safety. This wasn't a case so that the female was shooting back at the male, raising a gun toward the male, or the defendant attempting to defend his life. Instead, it was an attempt of cold-blooded murder And according to Judge Stoner, it was in order to, quote, eliminate the witness. A witness to what? The criminal confinement during an incident of domestic violence? Firing shots at police officers? The shooting and killing of Officer Breann Leath? Or was it the visceral fear of being the next to die? It was all of the above. And for this, Judge Mark Stoner sentenced the convicted defendant to executed time that he noted was below the advisory sentence. The advisory sentence of 30 years executed for the attempted murder. To add insult to injury, Judge Stoner then took the additional counts of criminal recklessness for shooting at 3 other IMPD officers and made those sentences concurrent with the attempted murder, meaning there is no additional time to serve. And finally, and astonishingly, Judge Stoner took it upon himself to disregard jury's verdict on the level 3 felony criminal confinement, which related to the female victim, and he lowered it to a level 6 felony and sentenced at the lower amount, and did it also concurrent to the attempted murder as well, meaning no additional time for that crime either. It should be noted, and it's important, the crime of confinement and the crime of attempted murder were separated by intervening time and intervening crimes. Additionally, the judge placed the defendant in 15 years, quote, mental health probation, which many folks have never heard of, with the expectation that the family of the defendant will be under a court order to notify the court if and when the defendant violates probation by failing to maintain his mental health treatment. The judge didn't stop there. He also reiterated that the defendant is criminally culpable but mentally ill, and then he stressed this point because it's confusing to many. Being mentally ill but culpable doesn't mean that you're not responsible. And he explained it this way. He said it may explain why he did it, but it doesn't excuse what he did. We agree. Judge Stoner also outlined his concerns that the defendant can be dangerous again and that it could happen again. Ladies and gentlemen, this is a travesty of justice. It dilutes the sanctity of life, the life of Officer Leath, the life of a domestic violence victim, and the lives of other officers involved. And just as importantly, the actions of Judge Mark Stoner has clearly conveyed a most disturbing message to violent offenders throughout Marion County. That is, that they can shoot at anyone, including officers, kill an officer, attempt to kill a domestic partner, and simply say they have a mental health problem of which there's no agreement on a diagnosis that can be reached, and they will receive a lenient sweetheart sentence in Indianapolis. That is your capital city of the state of Indiana. This is unacceptable. And it isn't just us saying it. It is the Leath family. We are joined today by Breann's mother, Jennifer Leath, who is here. It is also IMPD Chief of Police Christopher Bailey. And it is also the Mayor of Indianapolis, Joe Hogsett. We are confident many others in the community that Officer Leath has faithfully served feel the same way as well. Additionally, this is not a one-time matter, folks, but a repeated pattern from this court. We remind the community this same judge ruled in the murder of Southport Police Lieutenant Aaron Allen that the state failed to prove that the defendant knew Lieutenant Allen was an officer as he fired 18 rounds into his body while he was in a full police uniform attempting to help and then attempting to crawl away from the suspect in an overturned car crash. This is the same judge that we have highlighted before for another lenient sentence in a shot being fired at police officers in Indianapolis. As a result, the defendant, upon release from prison, is now alleged to have gone on to murder Officer Noah Chanovez. Enough is enough. Therefore, today, our collective organization of the Fraternal Order of Police calling for the following actions. The FOP calls on Marion County Judge Mark Stoner to step down from the bench. 2, We call for the Chief Justice of the Indiana State Supreme Court to immediately impanel a civilian review committee of the Marion County court system to reinstate confidence of the public and the police. Just a reminder, that's good enough for our police officers to have civilian review. It should also be good enough for our courts to have likewise. Number 3, we are requesting a meeting with the governor of Indiana to explore additional resources and executive action if needed. Number 4, locally, we call on Indianapolis Mayor Joe Hogsett in the Indianapolis City County Council to convene a commission on criminal justice outcomes for Marion County in memory of Officer Breann Leath and all domestic violence victims. We are encouraging this as the second step with a local focus of the existing law enforcement action to halt domestic violence, which has been referred to as the Leath Initiative in Bree's honor. And number 5, we call upon the state of Indiana to reevaluate the decision to make judges in Marion County unelected by its residents. Most people don't know, but judges in Marion County are now appointed after being reviewed and approved by an unelected body. The citizens' only recourse is a vote of whether to retain a judge every 10 years. By the way, we recommend in the interim, till we can get a handle on this, any judge that is up for a retention vote, we encourage Marion County residents, regardless of who they are, to vote no until they decide to fix these things. None of these points are made lightly. In fact, we do believe they are commensurate with the woeful outcomes and repeated tragedies we continue to witness as part of the revolving door of criminal justice in Marion County, Indianapolis, Indiana. And I want to close by quoting a prior decision by the Indiana State Supreme Court in another criminal death of a police officer, that of Muncie, Indiana police officer Greg Winters. His end of watch was January 8th, 1991. His widow is also here with us, Miss Molly Winters. And I quote, the court said that the killing of a police officer in the course of duty is a most serious crime. Police officers routinely risk their lives in the sometimes high-stakes gamble of protecting society. They do a job that we all want and need done, though few of us possess the bravery and the skill to do. They ask for little in return, but they do ask for some protection. That protection, ladies and gentlemen, I would put forward, and that I believe the court was talking about, is the protection of the law. Something these officers did not get here. We must do better. We can do better. We as police officers demand better because Indy can't wait. And with that, I'll take any questions that you have. Rich?
Can you see the judge's point of view at all in making some of these sentences consecutive or concurrent rather than consecutive?
No. And let me explain why. Look at the full context as I included here in my remarks of what took place here. These events were separate events that were transpiring in a mass attack that was occurring. I want to give this example because it's very relevant and timely. Accordingly, you have shots that were recklessly fired, shots that killed, 2 of which killed Officer Leath, 6 others that nearly struck 3 other police officers, and you have a person who then stood over the dead officer and fired 2 more rounds into the back of the female victim, fleeing from them. Let me ask you this question. Would this be appropriate to make them all concurrent so that there's no additional prison time if we had, let's say, the mass shooting in downtown Indianapolis where 7 juveniles were shot? Had all 7 juveniles been shot and some of them were because they were it was reckless homicide? Some of those because it was criminal recklessness, shooting a weapon and bullets in their direction, and then intentionally shooting 1 or maybe more of those victims? Would we say as a community that it would be appropriate in the full context of that mass incident of violence for sentences to be merged, basically, run concurrent, and no additional prison time occur because of that? I think not. So what's different here? Because police officers were involved? That's a significant concern. Because a domestic violence victim was involved, who otherwise may have never even had the voice to be able to talk about what happened here. We're grateful to her for her courage and for sticking this out, her tenacity to see it through to an end. Because, Rich, as you pointed out, had she not been shot in this defendant quite possibly would have walked out of jail free and clear yesterday, after the sentencing. After the death of an officer and nearly shooting 3 more officers. That's what's unacceptable. I can. So let's talk about what that means, can we? So there's 2 components that are involved. These are distinctions. The judge himself noted, and he wanted it on the record, that the sentence that he was imposing was below the advisory sentence for the crimes that he was ruling upon. That's number 1, which means he's saying the courts, the law says that the average regular sentence that should occur for these 2 crimes, this is for the first 2 crimes, reckless homicide and the attempted murder, the advisory sentence should be 33 years. 30 years for the attempted murder, 3 years for the reckless homicide. He did 25 years, right, for the attempted murder, executed. We're talking about executed time. He did 25 years, and then he did time served on the reckless homicide. Even best case scenario, that's still less than the 33 years that the law advises to sentence at. Number 2, let's visibly see the difference if we can. That's why I have this board. So bear with me on the sound. The maximum that prosecutors were arguing for was 63 years. That was the maximum for all the charges that were convicted upon, right? If you took the 63 years and applied the good time credit, which is 75% of the time, right? That results in an executed time of 47.25 years. That's what the state was arguing for. This is what Judge Stoner did. He then did 25 years executed, right? With credit for that good time behavior, we're looking at 18.75 years. Here's why this is important and where our outrage comes from. Based on what he did, he intentionally lowered accountability by 28.5 years. If you took that 28.5 years and included the 5 years credit for good time on the time that has already been served, that would even mean that at best, Judge Stoner's sentence is over 23 years less than what the state rightfully sought, given the facts of this violent series of attacks. I think any resident of Indianapolis, the state of Indiana, or this nation would agree that given the facts involved here, that is a disgrace. And it cheapens the lives, again, of not just Officer Breann Leath, the other IMPD officers, the domestic violence victim, but any future victims as well. Here's why. Judge Stone, even in his own remarks in the court, made clear that the defendant, in his opinion, still hasn't come to grips with the reality of what has occurred and his current state of affairs. He then went on to say that the defendant, he believes he can be dangerous again and it could happen again. This is exactly where we find ourselves abiding in the city of Indianapolis with the revolving door, where we have increased and repeat victimization as a result of these lenient sentences and the revolving door of criminal justice. Yes, ma'am. So the Supreme Court ultimately has authority over the court systems, the practices that occur within the courts, the rules that are the courts must abide by, including the attorneys as well. And what we are calling for is they can establish a committee, a board, that has the ability to review specifically the Marion County court system and get to the bottom of these kinds of incidents that are occurring. Not some bureaucrat, not somebody who's a lawyer, but a civilian who is impacted by all these things that says, we do not support this and we do not want this for justice in our community. And then that civilian board can provide feedback back to the state Supreme Court on how they can amend their rules or create new rules to ensure better guardrails for the courts to operate within. I think that seems particularly reasonable, and I think that we're beyond time to do that, because keep in mind the context. We now, for over 4 years, have sought every which way to address these issues short of that, including meeting with the Chief Justice of the Indiana State Supreme Court on 2 separate occasions to outline our concerns, and what we believe were going to be steps taken to correct these matters. Here we sit. So we're calling on them to take action. Now what is clear publicly is that they will either do this or they won't do it, and then they can explain why.
Rick, the crime of killing Officer Leath ultimately was decided to be a reckless homicide. Is it true that the maximum sentence of that was 6 years? And if so, isn't your grief or your beef, if I can, with the jury more than the judge?
Not exactly. First, I would say this. 6 years. Why not do the 6 years? Why not do the max? Why not still send that message? But here's what's important in the context of this, and this is what I think people forget oftentimes. The death of Officer Breann Leath did not happen in a vacuum. Proof positive of all the other crimes that the jury convicted upon. So would we have preferred that the defendant had found guilty of murder of Officer Leath? Absolutely. That did not occur. But what we were confident in, and we expressed after it occurred, we were confident that the court take the totality of the circumstances and apply the appropriate sentencing. And for God's sake, we had definitely expected that the court would have, at a minimum, abided by the advisory sentencing, if nothing else. That did not happen as a totality of counts 1 and 2. And frankly, since the other ones were concurrent, if you total it all up, it's still below the advisory sentence range. And here's my question. Why? I never heard a compelling reason why. In fact, most people in the community have reached out to us to say they felt like when they watched Judge Stoner's comments, which went on for nearly an hour, that he was treating the defendant more as though he was the victim in this matter. And nothing could be further from the truth. Other questions? I want to stress one final thing. The judge also made this point under mitigating factors. Because again, I think people get confused. Mental health issues are a big topic of discussion, rightfully so in our community, right? But even the judge made this point that the mental health issues were not much of a mitigating circumstance in this case. They didn't rise to the level of being significant enough to be taken into account. He noted things like educational challenges, but noted that there was no special education applied to the defendant. The only mitigating factors he could outline was no prior criminal history and that he was remorseful. Let me talk about that for a second. So we're going to say that it mitigates it if there's no prior criminal history. Would that then mean that we would aggravate if there was criminal history? And if so, is that occurring in Indianapolis? It is not, my friend. And shouldn't it aggravate the issue if you're a repeat convicted criminal and you've been rearrested for a new allegation of a similar type crime, especially of violence, should that not aggravate or enhance the bond that is issued for that alleged crime? It does not in Marion County. It is routinely set aside, thrown aside, cast aside. Folks are cycled right back out, and greater victimization occurs. Other questions? You're welcome to ask. Yeah, to ask her. The question was if Miss Leath wanted to speak at all. She's welcome to. She had no expectation for her to, though.
I love you. Thank you. Can you guys hear me? I just wanted to say that 1,000% we stand with him. I feel like whenever they dropped the charge from murder, because he murdered my child, when he dropped it from murder to reckless homicide, we took it. It was a gut punch to our family, but we took it. We took the higher road. We chose to not be whatever. I felt like our family was graceful in the fact that, we showed his family respect, that they lost up. They're going through this too. Aisha's family, that type deal. To be told that the whole time we're waiting on judgment, that didn't matter. Like, okay, you were in custody, so, okay, time served. That not only was a slap in our face, but that was just, you stomped on us and rubbed it into the ground like she literally wasn't there. That's not okay. That's not fair. Our family has been we have been good, upstanding members of our society and our community, as along with a lot of other people are. And I agree that you just basically said it's open season. It doesn't matter. You can kill people and say, well, I had a bad day. And there's no consequences. Nobody's held accountable. My daughter paid the ultimate price. So I just think that we absolutely need change. There's no reason for it. We piggyback on what he said. We sat there for an hour listening to him say that Breann was a great officer. She was the example. She was such a kind person. He understood our grief, and then just turn around and just basically throw his words in a shirt. And the hair that Mr. Dorsey is remorseful, no, he's not. No, he's not. Those fake tears, once again, no, he's not. And then to say that his family would be in charge of him when he got out, the same people that failed him to begin with, the same people are going to be in charge of him that didn't do anything before, like he said, it could happen again. So it's a very sad state of affairs our city and our state is in. And I agree that we need change at minimum. Do something. I'm begging as a mom, please take Breann as an officer out of the equation. A young mother who has left her child, was taken away, doesn't get to see him grow up. He was the air that she breathed, and now that's just reduced to dust. Come on, we gotta do better. That's all.
Thank you, guys. Thank you, dear.